Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
You're not going to sneak it in or slide it in during your opening or closing statements. Do you understand that?
Before I answer that question,
Mr. Martin?
The tension inside this courtroom escalates almost instantly. Before the judge can even establish basic order, the defendant begins demanding answers, interrupting the proceedings, and challenging the authority of the court itself. What makes moments like this so dramatic is that judges are trained to maintain strict control over the courtroom, and when someone openly refuses to follow that structure, every second becomes unpredictable. You can already feel the atmosphere shifting from a routine hearing into something much more volatile. The judge's warning about contempt is not casual courtroom language. It is a direct signal that patience is already running thin. And from this point forward, every interruption, every demand, and every refusal to cooperate only increases the risk of harsher consequences. The courtroom is no longer simply discussing charges. It is now battling over authority, control, and compliance in real time.
You guys hear me?
Yes.
Calling case number 24-01173-SM. This is the people of the state of Michigan versus Len Derek Tyler Stringer. Mr. Angot, do you wish to place an appearance on the record?
Judge John Angot, I'm here as appointed counsel for Mr. Stringer regarding this arraignment. However, Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as a beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, it is charged by the people of the state of Michigan that in this city of Royal Oak, county of Oakland, and state of Michigan, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your nipples in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. If the victim is a minor, it is a Tier 2 offense. If you have a prior conviction for a Tier 1 offense, it is a Tier 3 offense. If you have a prior conviction for a Tier 2 offense. This is a high misdemeanor, punishable by up to 2 years in the state prison and up to $2,000. Also, a mandatory collection of DNA identifying profiling samples. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure. At this time, the court enters not guilty pleas on both of these matters so that Mr. Stringer's presumption of innocence under the constitutions of Michigan and the United States are preserved.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today. If probable cause is either found or waived at that preliminary examination, the matter will be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. The court must now set bond in this matter. It's not intended to prejudge or punish you. You are presumed innocent, Mr. Stringer. However, the court must set bond in order to ensure your reappearance to court and afford any necessary protection for the public In that regard, the court would first hear from Detective Keith Baringa of the Royal Police Department. Then the court would hear from your attorney, Mr. Stringer. Detective Baringa, please proceed.
Personal bond.
He currently has 2 warrants out of the state of Texas for assault and also assault with injury to family violence out of Texas. He also has a lengthy criminal history out of Texas, going from his recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying information or government documents. I'm not sure if that's just like a generic false ID case or not, but multiple felons out of Texas. I'm not sure how long he's been in Michigan. He has no current cases out of Michigan I'm aware of. His criminal history, he has assault from 2019 out of Harper Woods, which looks like it was heard of as assaulting a public officer or obstructing, where he got served in a day. And that is it out of Michigan.
Anything further?
So I would also ask that he not be allowed to return to any public or private pools in the city of Pueblo or parks, grass areas adjacent to it. Or
Thank you very much. Mr. Angot.
Judge, as noted by the court, the presumption of innocence is absolute at this point. And so we must start from there. Mr. Stringer, or the person purporting to represent Mr. Stringer, is a business owner. Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Thank you very much. The following conditions will apply to Mr. Stringer's release. Mr. Stringer will appear for all his future dates as directed. He will abide any valid order or judgment entered in this case. Mr. Stringer, you will not leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. You will notify the court in writing of any change of address, telephone, or email. Mr. Stringer will be making reports to pretrial services, and they will supervise his release. There will be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician, and Mr. Stringer will abide a substance abuse testing and monitoring program. No purchase or possession of a firearm or other deadly weapon. Mr. Stringer shall not harass, intimidate, beat, wound, or threaten Linda Marino and Chad Stransky, nor will he cause, through himself or through any third party, to have direct or indirect contact with said individuals. Mr. Stringer will not enter the cities of Royal Oak or Berkeley except for court, work, or medical treatment. And at this time, there will be 2 ETGs per week for alcohol consumption and 3 controlled substance tests a month. Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this time. If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. $50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on? What's going on?
I'm sorry, sir.
I'm being charged. I'm charged.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
Mr. Martin was here and now he's gone, so
Mr. Martin was here, and now he is not here. What time was that one set? I was set for 8:30. People versus Eric Martin.
As the court moves into bond discussions, the situation becomes significantly more serious. The judge is no longer only focused on the current allegations, but is now evaluating public safety, criminal history, and the likelihood that the defendant will return to court. The prosecution's mention of violent offenses, warrants from another state, firearm-related charges, and assault accusations dramatically changes the tone of the hearing. In cases like this, judges are required to weigh risk factors carefully, and every prior incident becomes part of that equation. You can see the contrast clearly here. While the defense argues for release conditions like GPS monitoring, the court is balancing those requests against a lengthy history that suggests instability and potential danger. This is the exact moment where courtroom reality crashes into the defendant's unconventional arguments. No matter how loudly someone challenges jurisdiction or identity, the judge's responsibility remains the same: protect the integrity of the process and protect public safety.
Good morning, Your Honor. MIDC counsel on behalf of Eric Martin, Josh Hadley, P number 80080.
Alrighty. Today was the date and time set for a settlement conference. Mr. Martin had appeared and he signed out and is no longer here. He left the court, the Zoom court. There was also a motion and demand to replace his current attorney, Joshua Hadley. He would be the second or third attorney I think I've appointed to Mr. Martin.
I can't speak to it, Your Honor, but I do believe that that's correct. I know I'm not normally one of your house counsel attorneys. I was reached out and spot appointed on this. I believe I'm successor, maybe third attorney in the case.
Right.
Judge, he is back in the waiting room now.
Oh, wait, he's back in the waiting room now. Here he is.
And Your Honor, I was not served a copy of the motion to replace me, so I will not stand obviously in opposition if that's been filed with the court.
Well, it's been filed by Mr. Martin, so it was handwritten. Mr. Martin, turn your video on, please.
I'm doing that. All right.
This is People of the City of Taylor versus Eric Martin. Today's date and time set for a settlement conference in this matter. Mr. Martin, you had filed a handwritten motion to replace your attorney, Mr. Hadley. Mr. Hadley is like the second or third attorney that I appointed to you on this driving on a restricted license. And replace him, which will require another. It says that your attached motion, you'd like to fire the attorney and replace him, which will require another appointed attorney. Time to get familiar with this case and your defenses. So, there's nothing wrong with this attorney. What's the problem with this attorney? He's a very highly qualified attorney who I appointed to you. This is a driving on a revoked license. I'm not sure what the issue is here with this attorney.
Pointed out in the motion and demand to get rid of him was replace him was because
Hey, Mr. Martin, hang on. I can't hear anything you're saying because the tubes behind here. All right, go ahead.
Yeah, just as I pointed out in the motion, was because he told me that I can't say nothing during the trial. If he talks, I can't talk. Basically, I have to violate my own right to freedom of speech. And what was the other reason? Let me refresh over it again.
Okay.
And oh, there's other reasons. And plus, he kept talking about several times as he was talking. Not like it was a one-time thing, like normally happens. People don't intentionally, like, but also happened several times as though he showed he was doing it intentionally.
All right. So you say you want to talk at trial. You have two different options as far as talking at trial. One is you have the right to testify on your own behalf if you want to, and no one's going to stop you from testifying on your own behalf. Now, if you're planning on doing that, your attorney can ask you questions, and you can also be subject to cross-examination. Just letting you know, and you'll be under oath. So any sort of perjury or anything like that, you could be, subject to obviously the penalties of perjury if there was any sort of untruths that were stated by you on the record, on the witness stand. Now, the other way you would be able to speak on your own behalf is if you're representing yourself. So I think what Mr. Hadley is talking about is like if someone asks a question and he wants to say objection because there's a legal reason to say objection. I don't need both of you to say objection. Just one person can say objection. I think that's what it's going to be confusing if you're going to.
This exchange perfectly captures why sovereign citizen-style arguments almost always collapse inside a courtroom. The defendant attempts to separate himself from his legal identity by referring to a dead entity, believing that distinction somehow removes the court's authority over him. But judges deal with these arguments regularly, and legally, they hold no recognized weight. What makes this moment fascinating is the contrast between the defendant's confidence and the judge's calm dismissal of the theory. There is no extended debate, no confusion, and no hesitation from the bench. The court simply reaffirms jurisdiction and moves forward. That is why these hearings often become so intense. Defendants expect their arguments to fundamentally disrupt the case, but instead the proceedings continue almost unaffected. The emotional reaction that follows usually comes from realizing the strategy they believed would stop the process has had absolutely no legal impact whatsoever.
Try to talk over top of your own attorney when it comes to that sort of stuff. If you want to represent yourself, you're more than welcome to represent yourself, and you can talk. You can be the attorney. You can say objection and that kind of stuff. But in that situation, I would still have Mr. Hadley there as a standby so that you can ask legal questions. But there's no reason to fire Mr. Hadley. He's a very competent attorney, and this is a very straightforward case. You either had a license at the time you were driving, or you did not have a license at the time that you were driving. And all we have to have is, as far as the elements go, we have to have a witness that shows that you were operating a motor vehicle on a public street and you didn't have a license. Those are the elements of the case. So I don't know who the witnesses are. We haven't heard any testimony, so I'm not going to get into any of that stuff. But I'm pretty sure that Mr. Hadley can handle a case like this, or be the standby there sitting with you in case you have a legal question when it arises. So that's for that reason I'm going to deny your motion, because you have very competent counsel. You requested counsel, and I don't see any legitimate reason to fire this attorney and hire a new one, especially when you stated right in your motion that our attached motion and demand to fire the attorney and replace him, which will require another appointed attorney time to get from there. I'm not kicking this case down the road again and adjourning it out again, just so that we can stall for more time. So there's literally nothing in the elements that Mr. Hadley isn't aware of. So I'm going to deny your motion. Now, if you want to represent yourself, I'll have Mr. Hadley be there as your standby attorney, so that you have an attorney that you can ask questions to right in the courtroom. Or Mr. Hadley will be the one who's going to represent you. And if you want to testify, that's entirely up to you.
Your Honor, if I may briefly, as Mr. Martin's waived attorney-client as to the contents for communication, I've never told Mr. Martin that he was not allowed to testify on his own behalf. For the record's sake, Mr. Martin has proposed that we would have dual opening arguments and dual closing arguments if there was a difference in trial strategy. I've explained to him that the court's not going to entertain tag teaming this proceeding.
You know
with
what?
two openings,
I got
two
listen.
closings.
If you want to say a closing, and he wants to say a closing, sure, go ahead. I got no problem. I got. Listen, I got no problem. The court is not. The court is very, 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 very astute in the law. And you know what? If you want to talk, you want to do an opening argument, you want to do a closing argument for yourself as well. Listen, I'm just going to remind Mr. Martin that you have a right to remain silent and not have any of that silence used against you. But
Mr.
if you
Martin.
want to get up, and speak, I'm going to caution you right now of what you're not going to do. One, you're not going to testify until you've actually testified. You're not going to talk about things that are not in evidence. So if you're going to be like, hey, I did this or they did this in the opening statement. Now, if you're going to want to say that it's going to, like everybody else does in their opening statements, here in this trial, the evidence will reflect, or the evidence will prove X, Y, and Z, talking hypothetically. Sure, but if you plan on not testifying, then you better not testify during your opening or closing statements, because you're not subject to cross-examination at that point, and that would be unfair for the other side. If you are going to testify about your own opinions, about your own statements of fact that you think happened, you're going to do that on the stand if you want to do that, or you're not going to say it at all.
At this point, the judge shifts into full courtroom management mode. Instead of arguing emotionally with the defendant, the court carefully explains the difference between representing yourself, testifying, objecting, and participating in trial procedure. And this is where many self-represented defendants underestimate how complex criminal proceedings really are. The courtroom is governed by rules of evidence, timing, procedure, and strategy. What the judge is explaining here is critical. A defendant cannot blur the line between witness and attorney whenever it becomes convenient. If someone wants to speak as evidence, they must testify under oath and face cross-examination. If they remain silent, they cannot secretly insert testimony into opening or closing statements. The judge is essentially warning him that courtroom procedure is structured like a system of checks and balances. Ignore those rules, and the court can immediately limit or reject what you are trying to do.
So if you're going to testify during your opening or during your closing statements, then you're going to testify on the stand. But if you're not going to testify on the stand, which is your choice, you have the right to remain silent on that, then you're not going to bring up things that aren't in evidence, because your testimony isn't in evidence. So you're not going to sneak it in or slide it in during your opening or closing statements. Do you understand that?
Before I answer that question,
Mr. Martin, the answer is yes or no. Do you understand the statement that I just stated?
I comprehended it.
Okay, you
but I
comprehend it.
wanna say
Very good.
something else.
So next topic is everybody's ready to go. That is set for the trial, and we'll see everybody here for trial.
I have some objections, and I have something else to say. Now, I never said that Joshua never said to testify. He wasn't talking in that. I couldn't speak. He was.
It's already been resolved. It's already been resolved. If you want to make an opening statement, you can make an opening statement. If you want to make a closing statement, you can make a closing statement. So yeah, I got no problem with both of you making the opening and closing statements. And with regard to testimony, if you want to testify, you can testify. If you want to remain silent, you have that constitutional right to do that too. So court's not stopping you from doing any of that. Okay? So the motion to remove Mr. Hadley has been decided. So there's no more need nor discussion before that. I've already made my ruling on that. So that was the point of today. Was your motion was up for today. We made a ruling on that motion, and we'll see everybody at trial. Have a good rest of your day, sir.
I have a motion to make
Briefly,
a motion to trial based on the motion that I filed to the case and I have not been ruled on yet.
So you say your motion to dismiss?
I have several motions to dismiss already filed in this case that are
Right, and I already ruled on your motion. I already ruled on your motion to dismiss. And then if you're just going to refile the same thing, then it's still dismissed. You can't just keep filing the same motion to dismiss.
Now, on those same motions. Now, I'll go over the motions I'm talking about specifically here. One based on the 11th. That I, August
So
19th.
we'll hear any other motions on the day of trial. So be prepared because we'll hear those in person here and before the trial starts, if the trial starts. Because if your motion is successful, then we obviously won't start it. But we're not hearing those today. Those weren't scheduled up or noticed up to be heard today. Those are going to be heard on the day of trial, so we can do them here in person. And then if your motion is successful, then we won't have trial. If it is not successful, then we will. But that way everybody will be ready to go on that same day. So we're going to see everybody on the day of trial, and any other motions that you have, we will take care of at that time. Mr. Hadley.
Your Honor, one, I would like to get a working phone number from Mr. Martin. I've been unable to reach him for several weeks.
Mr. Martin, do you have, I'm going to put you into a breakout room because I don't want to broadcast your information online.
And then second, Your Honor, I've been
Mr. Martin, hang on. Mr. Martin, hang on. Mr. Martin, hang on. Mr. Hadley, what was the second part of your?
Thank you, Your Honor. I have not received or been able to get copies of any of the pro se motions that have been filed other than the motion for a hearing to determine nature, cause of case. Would it be acceptable to reach out to your staff to get copies of these pro se motions in advance of the trial next week?
Yes.
Thank you. That's all I have, Your Honor.
All right. So Mr. Martin and Mr. Hadley, I'm going to put the two of you into a breakout room so that you can swap information as far as phone numbers and things like that. So there you go.
Thank you, Your Honor.
Here.
Yep. That's a verbal motion.
All right. So go ahead and talk with Mr. Hadley in the breakout room. You can sign out from there.
Bernard, Brandon Little.
Speaking. Here.
City of Detroit, Bernard Brandon Little, case number SP 1513015, counts 1, 2, and 3. SP 1513091. SP 1556287, counts 1 and counts 2. SP 1556352, counts 1 and counts 2. SP 1556353, counts 1 and counts 2. Appearance for the record, please.
Elwood Esberry Jr. on behalf of the defendant. State your full name, Mr. Little.
Bernard.
Your full name?
Bernard.
You're
I'm not the corpse. I'm not the corpse. I'm not the fiction that they send me. The caps. I'm not that caps.
So who gave you the last name Little? Your mother?
The government did.
Your mother didn't give you that last name?
The government gave it to me.
She had to tell the government, didn't she?
The government. She was an agent of the state.
She was an agent of the state? All right. So what are we going to do with these cases, Mr. Little? Or Mr. Bernard?
I would like to know which jurisdiction I'm being tried under so I can adequately defend myself, Your Honor.
Read the court rules. I'm not here to give you a law school instruction. Read the court rules.
What do you mean? As a matter of record, I would like it to be placed on a matter of record how I'm being, what venue you are using, Your Honor.
That's not my obligation, okay?
What do you mean it's not your obligation? It is your obligation. You took an oath to uphold. Excuse me.
What began as a series of routine hearings quickly evolved into a dramatic showcase of courtroom control, sovereign citizen arguments, and the risks of self-representation. Throughout these proceedings, the judges repeatedly attempted to explain legal procedure, clarify constitutional rights, and maintain order while the defendants challenged authority, questioned jurisdiction, and pushed unconventional legal theories. In every instance, the court stayed focused on procedure, evidence, and compliance with the law rather than emotional arguments or disruptive tactics. The hearings also highlighted an important reality. Criminal courtrooms operate under strict rules, and misunderstanding those rules can create enormous legal consequences for defendants trying to navigate the system alone. Whether it involved bond rulings, trial procedure, or competency evaluations, The judges consistently reinforced that courtroom authority does not disappear simply because someone refuses to recognize it.